أعوذ بالله من الشيطان الرجيم. بسم الله الرحمن الرحيم.
السلام عليكم. الحمد لله رب العالمين والصلاة والسلام على رسول الأمين وعلى آله وصحبه أجمعين. Inshallah, we are going to cover the lesson 2 and today. Last class we had covered the introduction to the Islamic law of inheritance, the importance of learning the Islamic law of inheritance, Prophet Sallallahu Alaihi Wasallam's hadith, and the Quranic verses we have learned. I hope all of you have by hearted the same. We are going to cover the next lesson. In this lesson, general things to be known are taught. Understand these. First we go to the overview of things to be learnt. What are all things to be learnt in the Islamic law of inheritance? First is the pre-Islamic inheritance. Before Islam, what was the Arabic customs? Second one is the Islamic inheritance and the events leading to the revelations of the Quran. Third, comparative with other religions. Then we have the components, the eligibility and the conditions to be fulfilled, the obligations, and the loss of right to inheritance, and the most important, the heirs. The next, the order of inheritance and the special rules, awl and rad, exclusions, and how to work up of a case, and wasiya and special cases. These are the chapters we are going to cover in the next few sessions. First we go to the pre-Islamic Arabia. Before Islam, only those who fight in the battles were entitled for shares. That is, only male relatives were heirs to the property. The females were totally excluded for the reason that they were not going to fight in the war. But the Quranic revelation changed this, and 8 females were included as fixed heirs. Second thing is the adoption. Pre-Islamic Arabia, adopted children were given inheritance rights and they were called by their adopted father's name. As we all know, Zayd bin Haris was called Prophet's son. Islam rejected this by the following Quranic verses. That is Surah Ahzab. God has not made any man two hearts, nor he made your wives whom you divorced by zihar, your mothers, nor has he made your adopted sons your sons. Such is only your speech by your mouth, but God tells you the truth, he shows the right way. Call them by father's name, that is just in the sight of God. But if you know not their father's names, then call them brothers in faith or your mullahs. But there is no blame on you if you make a mistake therein. What counts is the intention of your hearts. God is oft returning, most merciful. This is the ayah 40 of Surah Al-Ahzab. Muhammad is not the father of any of your men, but he is the apostle of God. Another thing which was prevalent in the pre-Islamic Arabia was oath-taking. Before revelation of Quran, Arabs were taking oaths among friends regarding inheritance. That is, who has to inherit, they used to take the oaths. But Islam rejected this, but allowed property sharing during the life of a person. After the death of a person, property has to be distributed among relatives and not to be given to the others except by way of wasiyat, not exceeding 1/3. Again, Surah Al-Ahzab, ayat number 6. Blood relations among each other have close personal ties in the decree of God than the brotherhood of muhajirs and believers. Nevertheless, do ye what is just to your closest friends. Such is the writing in the decree of God. Again, Surah An-Nisa, ayat number 33. To everyone we have appointed shares and heirs to property left by parents and relatives. To those also to whom your right hand was pledged, give them due portion, for truly God is witness to all things. Now we come to the circumstances of revelation. This Sa'ad bin Rabi'ah's case. Jabir bin Abdullah reports, Sa'ad bin Rabi'ah's wife with her 2 daughters reaches Prophet's place and complains that Sa'ad's property after his death, becoming Shaheed in Uhud, has taken away by his brother. Nobody was willing to marry Sa'ad's daughters without property. Prophet ﷺ told her to wait, as Allah has not given any knowledge regarding this. During this time, Prophet ﷺ started getting wahi and recited the ayat from Surah An-Nisa. Prophet ﷺ then called Sa'ad's brother and commanded him to give 2/3 to the 2 daughters, and 1/8 to Sa'ad's wife, and the rest for him to take. The first division of the property in Islam is this incident. The comparisons with other religions. Most of the religions of the world distribute the property in the following manner. One is the testamentary succession, that is based on will. The person makes a will before the death on how the property should be distributed. This is followed by most of the religions in the world. And the second manner is intestate succession, that is, suppose the person does not write a will and dies without a will, then how the property is to be divided. So these are the basic 2 methods how the property is divided in other religions. But the salient features in other religions are the ascendants like father and mother are excluded. It's an irony that father and the mother who brought up the child, the sons and daughters, they are excluded from the property after the death of their siblings. This is the practice in other religions. And again, the female relatives are excluded. There is no share for the females, except recently the certain countries in the world have included the females. Spouse given full right of inheritance in some places, and the only agnates inherit. That is, the male relatives, the close male relatives inherit. That is the system which was followed before the Islam in Arabs. Primogeniture, that is, eldest son preferred over others. The other sons were not given the share in the property. The eldest son is given. And the difference between ancestral and personal property, this is still followed in some religions across the world. That is, the ancestral acquired properties and personal properties, there is a difference of distribution. But the most important difference is, in other religions, the testamentary succession is of primary importance. That is based on the will, governed by the laws of government and the man-made rules which keep changing depending on the case. And all over the world this is followed. The person makes a will, and based on that the property is distributed, and if he doesn't make a will, then there are set rules by the government which is man-made again and which keep changing over a period of years. But in Islam, the difference is that intestate succession is of primary importance. That is, the succession or the inheritance based on the will is only 1/3 of the property, and the rest is divided by the divine decree. This is governed by the divine revelations of Quran and Sunnah and are fixed and permanent. Nobody can change it, and it has been there for the past several hundred years. Coming to the right of females. Many argue that in Islam there is no proper representation for females, and females get only a portion of the share. But actually the opposite is true. As I said earlier, in most of the religions of the world, the females were excluded. Only now recently the females are included in the inheritance shares. And even in India and even in the English system, the females were included quite recently. Whereas in Islam, the female's position was made evident when the Quran revealed the inheritance verses. It included 8 females in the inheritance shares. Now most of the people who antagonize Islam argue that the females don't have a proper representation in inheritance. But it is actually the opposite is true. Female gets a share and her share is always fixed in inheritance depending on the situation. Now in Islam, a lady's protection and expenditure is made by males, that is either by son or father or brother. A lady need not pay anybody's expenses, but a male is commanded. And financial burden on man in Islam is much more. The man has to look after the family. And in marriage, a man has to bear the expenses and he has to pay the meher, but woman does not spend but gets meher in addition. All these points point to that the females actually they don't have to spend anything, but they get a share in Islam. Now what are the components? Now we learned the pre-Islamic Arabia, how it was divided, and then comparison with other religions. Now we go to the components. There are three things should be there: the propositus, or the deceased, or the one who died. The inheritance rules apply or applicable only after the person's death. The second one is the one who inherits, or the heirs. The third thing is the property. These things should be there. Now we go to the first one, the propositus, or the deceased, or the one who died. The death of a person witnessed by others or officially declared dead if he is missing. The second one is the one who inherits, or the heir. The eligibility for a heir are, the main things are two. One is the marriage and blood relations. The third one is the freeing of a slave, is of not much importance these days. The marriage, it should be legal as per Sharia. In talaq, inheritance is valid till two talaqs. So that is how the husband and wife, they inherit each other. And the second most important is the eligibility. The cause of eligibility is the blood relations. That is the main eligibility condition. The third one, as I said, freeing of a slave, is of not much importance these days. The third thing is the property. It should be free of obligations. Now what are the obligations? Before the property goes to the inheritors, the following obligations must be fulfilled from the property. That is, there is any others' wealth or property, unpaid price or mortgage or rented property, all these to be settled before you settle the inheritance property in the proper manner. The second thing is the funeral expenses to be borne from the dead person's property. Third thing is the debts. And fourth one is a wasiyat, not exceeding 1/3 of the balance after the above, except if inheritors agree. So all dead persons, all unpaid price, mortgage or any renters pending, all these things to be settled. Then the funeral expenses, and see if there are any debts. And the fourth one is the wasiyah. Now coming to the debts, there are two. One is towards Allah, like unpaid zakat, kafarat and nadar. Second one is towards humans. They all agree that debts to humans should be settled, but that of Allah, there is a difference of opinion among the scholars. Ali bin Abu Talib said, "You people recite this verse." That is after the fulfillment of the legacy or debt. That is the verse we read in the inheritance verses of the Quran. Min ba'di wasiyatin yusuna biha aw dayn. After the fulfillment of the legacy or debts. But Allah's Messenger ﷺ decided that a debt should be discharged before a legacy. Legacy is a will. So in the Quranic verse, it is the will which comes first, but the Messenger decided, and that was the practice, that a debt should be discharged before a will is fulfilled. From Amr bin al-As, the Prophet ﷺ said, a believer's soul remains in suspense until all his debts are paid off. Abu Huraira reported, whenever a dead man in debt was brought to Prophet ﷺ, he would ask, has he left anything to repay his debts? If there was something to pay his debts, he would offer funeral prayer. Otherwise, he would ask others present there to offer the prayers. This shows how important the debts are to be cleared before the death. Second thing is debts to Allah. If it is mentioned in the will, it becomes obligatory. If the person before he dies, he makes a will mentioning that all his debts and it should be cleared, then it becomes obligatory. Like the Hajj, if he has not finished his Hajj or any other. Hanafi and Maliki feel that the debts to Allah, the inheritors need not pay. But in Shafi and Hanbali, they are of the opinion that it should be paid. But Shafi and Hanbali are of the opinion that it should be paid. Basis for this is hadith reported by Ibn Abbas. A woman from the tribe of Juhayna came to the Prophet and said, my mother had vowed to perform Hajj, but she died before that. May I perform Hajj on her behalf? The Prophet said, perform Hajj on her behalf. Had there been a debt on your mother, would you have paid it or not? So pay Allah's debt as He has more right to be paid. Based on this, Shafi and Hanbali are of the opinion that the debts to Allah should be paid irrespective of whether it is mentioned in the will or not. Now, what are the conditions? As I said earlier, it is the death of a person witnessed by others or officially declared dead if missing. The heir should be alive, present in person. If the heir is dead, then he is not entitled for inheritance. If the heir is missing till the declaration of the death, and child in the womb also is eligible. And third is the establishment of the relation. Now, what are the things where the right to inheritance is lost? For the following reasons, a person loses the right to inheritance. Slavery, killing of a person, either intentional, unintentional, or by mistake, or indirectly. But there is a difference of opinion among the scholars and the different conditions. I'm not going to discuss those things in detail here. The third is the citizens of two ideologically different enemy nations. Fourth is a different religion, they don't inherit. Fifth is the Ridda, or leaving Islam, that is equals death, he loses the right to inherit. Sixth one is the ignorance of time of death and not knowing the correct identity of the heir. Alhamdulillahi Rabbil Alamin wa akhiru dawana alhamdulillahi Rabbil Alamin. We have covered the lesson 2. The most important things are the circumstances of revelation, the Pre-Islamic Arabia and the components, and what are the things where the right to inheritance is lost. Inshallah, we'll cover the next lesson in the next class.
ربنا تقبل منا إنك أنت السميع العليم